Welcome to The Explainer. Today, we're diving into a topic that has honestly incredibly high stakes for our local economy, and that is navigating commercial lease disputes right here in Overland Park. For local business owners and landlords alike, the commercial lease is really the foundation of your entire day-to-day operation. But when a disagreement pops up over that document, well, it's not just a minor headache. It is a highly stressful, potentially business-ending reality. Whether you own the property or run the storefront, a dispute can literally freeze your cash flow, halt your operations, and drain your resources in just a matter of weeks. So today we're going to break down exactly how these conflicts start, what your rights actually are, and how you can resolve things without totally destroying your business relationships.
Okay, let's just quickly glance at our roadmap for today. First, we'll look at the anatomy of a dispute, then move right into rights and legal realities. From there, we'll decode the lease agreement, and finally, we'll talk about resolving things outside the courtroom.
Section 1. Anatomy of a dispute. Let's look at the root causes of conflict and how these stressful situations actually begin.
So are you stuck in a lease deadlock right now? When landlords and tenants stop seeing eye to eye, the situation can devolve into a total standstill so fast. And for business, this kind of deadlock is an immediate threat to survival. You simply cannot run a successful company if you're constantly battling over the literal building you operate in. So how exactly do we get to this point of total paralysis?
Well, almost all the chaos stems from 4 common triggers. First up, non-payment of rent. That is absolutely the fastest way to fracture a relationship. Second, property maintenance disputes. Because, let's be real, nobody wants to argue over who pays for a broken HVAC system when it's freezing outside and your customers are shivering. Third, lease term violations. This is when a tenant uses the space for something unauthorized. Imagine turning a quiet retail shop into a noisy late-night venue overnight. And finally, disagreements over lease renewals or terminations. That happens when one party wants out or wants to change the terms, and the other is just totally blindsided. Pretty much every major legal battle starts with one of these 4 seeds.
But here's the thing. Disputes over these issues rarely happen overnight. They usually start with really subtle warning signs. We're talking an unreturned phone call from a property manager, maybe an email that suddenly takes on a super tense tone, or just a single late rent payment. If you can spot these behavioral shifts early on, you can open up a dialogue and actually stop the conflict from snowballing into a full-blown legal crisis. You gotta nip it in the bud. Moving on to Section 2, Rights and Legal Realities. Let's explore the Kansas law boundaries for both sides of the contract. What's super interesting here is how Kansas law neutrally balances the playing field. On one side, tenants are protected by what's called the right to quiet enjoyment. That basically means the landlord can't just barge in and disrupt your business. You also have the fundamental right to a functional space. But flip the coin, and we see the landlord's authority. The property owner has an absolute right to collect timely rent, enforce the lease rules, and expect their property to be maintained properly. So neither side holds all the cards here. It's really an ecosystem built on mutual obligations.
However, if those fundamental rights get ignored by either party, the consequences are incredibly harsh. Failing to respect these boundaries can trigger some severe legal remedies. For the tenant, holding back rent can lead to a really rapid eviction process. And for the landlord, failing to fix critical property issues might actually give the tenant the right to break the lease early and seek damages. It's a costly, stressful nightmare for both the property owner and the business, which is exactly why understanding the rules of the game is absolutely crucial.
All right, Section 3, Decoding the Lease Agreement, because this document is your ultimate rule book.
The very second you sense trouble, there are 4 critical clauses you absolutely must review. First, the Dispute Resolution Clause. This is your first stop because it often forces both parties to try mediation before anyone is even allowed to file a lawsuit. Then you have the Default and Remedies Clause. This spells out exactly what happens if you break a rule. Next is the Maintenance and Repairs Clause, which is so vital. It assigns explicit responsibility for upkeep, showing exactly who pays for the plumbing or the property taxes. And finally, the Use of Premises Clause, which restricts how the property can be used. If you know what these 4 clauses say in your specific contract, you're holding the key to resolving your dispute. But what happens if the language in there is kind of vague or confusing? Well, if you find ambiguous terms, you should take these 3 steps immediately to protect yourself from surprise costs later. Step 1, and this sounds obvious, but simply talk to the other person. Don't wait for a fight, sit down and review the document together. Step 2, get legal advice. Have a professional look at that muddy language. And step 3, create a signed, written add-on to the lease that clearly defines what those confusing terms actually mean. The simple 3-step habit is basically an incredible shield against future misunderstandings.
And that brings us to Section 4, resolving outside the courtroom. Here is how you can bypass the judge entirely when a dispute does erupt.
The really great news here is that traditional, slow litigation is not your only path. Actually, avoiding court is almost always the absolute best move for your wallet and your sanity. Going to trial can take months, sometimes even years, and the legal fees, they can literally cripple a small business. That is exactly where alternative dispute resolution comes in to save the day.
One of the absolute most powerful forms of this is mediation. This is a voluntary, completely private process. Basically, a neutral third party, the mediator, sits down with both the landlord and the tenant. Now, they don't act as a judge, and they don't issue orders. Instead, they just facilitate a conversation. We highly recommend exploring mediation, like the expert services offered locally by Bouse Mediation right here in Overland Park. Why? Because it empowers both parties to collaboratively dictate the outcome and, most importantly, keep their working relationship intact.
Now, if mediation fails and you just cannot reach an agreement, you've got to weigh arbitration against traditional litigation. Arbitration involves a neutral arbitrator who makes a final binding decision, but it's generally much cheaper and way faster than court. On the other hand, litigation happens in a public courtroom with incredibly strict rules, whereas arbitration remains a totally private, flexible process. If you want to keep your business matters out of the public eye and get things resolved quickly, arbitration is for sure a far better choice than going to trial.
It really all boils down to this quote. By sorting things out like this, you stay out of court, which is often in the best interests of everyone. That honestly perfectly summarizes our entire explainer today. Maintaining a strong, private business relationship through alternative resolution isn't just a smart legal strategy. It's the ultimate win-win. It lets the landlord keep a paying tenant, and it lets the tenant keep running their business without a massive disruption. So, I'll leave you with this. How will you proactively protect your Overland Park business relationships before the next dispute even begins? Seriously, don't wait for a missed rent payment or a broken air conditioner to finally find out what your lease actually says. I highly encourage you to pull out your commercial lease agreements today, review those critical clauses we talked about, and plan out your resolution strategy right now. By staying informed and communicating early, you take total control of your business's future. Thanks so much for joining me for this explainer, and keep learning.